Hello everybody and welcome back to the.universary. This video is going to encompass 3 hearings in 3 different courts, all of them small claims cases. This first one is before the Honorable Judge Williams out of Georgia. This is Maurice Crossley versus Flats at Perimeter Place. Mr. Crossley was supposed to be getting some money back after he moved out of the Flats at Perimeter Place, and they didn't follow through. Surprise, surprise! Let's see what the judge has to say. And any
All right, Mr. Crosley, can you unmute for me?
Hello,
How are you?
I'm pretty good.
All right, Mr. Crosley, can I get you to raise your right hand for me? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Your Honor.
All right, I appreciate you, sir. You can put your hand down. And you have filed a suit against Flats at Perimeter Place, is that correct?
Yes, Your Honor.
All right, and I'm showing that you did serve the corporation and they failed to file a timely answer. So again, this matter is in default. You have asked the court for $7,397.04 in damages.
Yes,
All right, and you can just give me some evidence on how you got to that number. And if you need documents pulled up that you have already sent in, just if you can, kind of direct us to maybe the label of the document so that Ms. Willis can pull it up for you.
Gotcha. The first one would be the statement of claim. It kind of gives a great summary on what kind of went down, and then I have supporting evidence as well.
Okay, and again, so it's in default, so I can you can just kind of briefly tell me what really briefly tell me why you have damages.
Absolutely. So throughout around December, I notified the flats as far as like there's extreme mold in my apartment. And then from the point of December up till March, these problems were never rectified. They kept kind of giving me the runaround. Toward the end of my lease, or toward March, I kind of notified them and I said, I can't live here. Between December and March, it ended up turning out that I was staying in either a hotel or staying with my mom or like going to my car in the middle of the day just to get relief from the mold. I ended up seeing an ENT doctor and they notified me, and there's supporting evidence provided that I'm allergic to mold. So it's really not a place I can be in. And I ended up talking to the property manager, and she notified me around, I think, March 31st when I turned my keys into her. She notified me that all the treatment that they had done for the mold wasn't appropriate. The person was spray painting the mold to like make it to mask it rather than actually treating the mold. And I have like audio of that if necessary. But over the course of December, January, and February and March, like I wasn't able to actually live in my place in any way you would expect to when you're paying rent every month. And then I also have on there the safety deposit that I didn't get back when I stopped living there. And I have pictures of the state that I left the apartment in, same condition I got it in basically. And then hotel cost 185. I spent one night in a hotel, found out that was too expensive to really sustain. And then I have the cost for my ENT visit, and I have the cost for my allergy test. And in total, that came up to the $7,397.04. And then I also had asked for like any kind of fees that they tried to issue onto me after this to just be like kind of nullified. Just in case, because they tried to give me with like a lease break, talking about an oven cleaning, talking about a partial amount for a lease break. And it was like I had a conversation with them when I turned in my keys, and that's kind of the summary in short.
Okay, so I can definitely address your issues that were the result of the mold treatment. Now, as far as anything that they have charged you with, have you made any payments
I have
toward?
not.
Okay, so that's not in front of me today, so I can't give you a windfall of something that you have not paid for yet, if that makes sense. Now,
Absolutely.
you are able to defend yourself if in the future they do come at you with those charges. So let's look at the you said there was one night in a hotel for $185.
Yes, ma'am.
All
Yes, sir.
right. All right, and then the ENT visit, how much was that?
So the visit itself was $40, and then going to get my allergy test to kind of like be able to substantiate my claim that like I'm having a really hard time with the mold was 387.20.
387.20. Okay. And let me just have the calculator handy. 185 plus 40 plus 387.20. All right. So we're at 612.20. What else was there?
There was the safety deposit, which was $400 that I didn't get back.
You said safety, the security deposit that you paid when you first.
Correct. Yeah, sorry.
Okay, and you did not get that back based on.
Just on the fact that like it wasn't an amicable split. It wasn't like there was no like in process. I turned in my keys and there was no that end of your lease where you kind of like, here's your safety deposit. There was no kind of agreement there. So it kind of just it lingered.
And how much was your safety deposit, your security deposit?
400.
Okay, I'm going to take that charge under advisement. All right, and what else do you have?
And then I had rent for December, January, February, and March.
Rent for December, January, February, and March?
Yes, Your Honor.
And that's rent that you paid?
Yes, Your Honor.
Okay, and where did you stay in December, January, February, and March?
Yeah. So during like when I would have to work, I would go into my apartment to stay, but for the most part, it was either some mix of my apartment, my car, Starbucks during the day to like work sometime just for some relief, and then with my mom.
Okay, and what was your rent amount?
For each month, it kind of varied because there's like different fees. In December, it was 1567.66. And then in January, it was 1599.91. In February, it was 1621.61. And then in March, it was 1595.48.
All right, and do you have any evidence showing that you did not, well, you said you stayed in various places. I'm going to take that under advisement as well. That's a lot. That's 4 months of rent that was continuing to be paid versus, you leaving the apartment altogether. So I'm going to take those charges under advisement. Is there anything else?
Those are the only charges that I have for them. Yeah.
Okay. All right, sir. Well, I will take this case under advisement and I will issue an order and you'll receive a copy of that order. Okay.
Okay. I appreciate you.
Thank you, Mr. Crosley. Have a good night. All right. And let's see, Attorney Dunn.
All right, I hope you enjoyed that first case. The second one is Portfolio Recovery Associates versus Quayne Mitchell before the Honorable Judge W.T. Kemp, who, as I said in a previous video, is a new favorite of mine. Now, this one, first of all, I love Mr. Mitchell's accent. It is fabulous. Second, this case is really old, and Mr. Mitchell had a credit card through Bank of America. It went to collections. They sold it to Portfolio Recovery Associates.
Let me just call again. Position 119M 11132, Portfolio Recovery Associates versus Quayne Mitchell.
Yes.
And Mr. Mitchell, I know you're here. Thank you. I appreciate it. I'm calling again for the plaintiff's attorney. Is there a plaintiff's attorney or owner, agent, or representative present for Portfolio Recovery Associates? If so, please turn on your video and unmute for me. Mr. Mitchell, this case is old.
It's been very old, Judge, and the thing about it is that I was the one who visited the courthouse on several occasions to ask why wasn't it being heard. And on the last occasion, I received a notice 2 weeks after that the date was set because I was just told nothing whatsoever, right? What I realized is that the attorneys in Alabama for Nathan and Nathan, I'm not sure if they have any authority to be collecting a debt within the state of Georgia. And I have provided a notice to the court. It is not my desire to be utilizing the court's resources in this fashion. I am not representing a defendant. After careful reading of the statutes, I realized that the attorney could be misleading the court in the sense that, according to the Supreme Court of Georgia, it says that the plaintiff and the defendant must be legal entities. And there are just some material errors where this case is concerned, and I'm asking the court to carefully scrutinize the record as it may be very ripe for a dismissal. I thank you.
So So, Mr. Mitchell, are you asking me to dismiss this matter today?
Thank you, sir. That's my desire, if you may.
All right, I'm going to take it under advisement. The case is older. I may dismiss for want of prosecution. That's a term of art, meaning that it's not dismissed on the merits. The plaintiff can refile if appropriate and in accordance with Georgia law. But I may dismiss it for want of prosecution to remove it from the calendar. The statute of limitations does apply, and I'm not passing on what the statute is in your case. There are different statutes in Georgia. There's a 1-year statute, a 2-year statute, a 4-year statute, a 6-year statute. And depending upon some crimes, there can be a lifetime statute. But obviously that doesn't apply here. When you dismiss for want of prosecution, it's where one party does not appear. And because of the totality of the circumstances, the case needs to be removed and dismissed at that time. My usual practice is to allow both sides one opportunity to appear, but because of the age of the case and your specific request, I'm going to take that under advisement. All right, Mr. Mitchell, I do not need to schedule a new court date right now because if a new court date is required, you should get notice. Just make sure that, well, I don't want you to feel like you got to keep the clerk updated with your address forever. That doesn't make sense.
Well, it's been a long time, and I've made several trips because when I did my answer, nothing was done. I made several trips. It was just sitting there. Nobody paid attention to it. It's like from 2019.
I understand, Mr. Mitchell. Well, like I said,
I have tried reach out to the attorney on several occasions. They answer the phone inside an office here in Georgia. Nobody want to give any information until I realize that it's really from Alabama, not Georgia. But I appreciate it, sir.
And I understand your position. Like I said, I'm going to take it under advisement, your motion to dismiss.
I appreciate it, sir.
All right. Well, thank you, Mr. Mitchell. I appreciate you being here.
Am I free to go?
Yes, sir. And I really appreciate you being present. I tell everyone this all the time. Court is always better when people show up.
I was actually at my computer last month, the 7th. Thought it was for the 7th of May and not June. It's important that it be dismissed. But I appreciate your time, Judge. Thank you.
All right. Thank you, Mr. Mitchell. All right. Please take care.
Excuse. Yes.
Yes, sir. Please take care.
All right, for our final case of the video, we have Lisa Grice versus Justin Matheny, who is a no-show. But that's not really why I included this case. Judge Middleton has some perspective on the way Ms. Grice has decided to show up to court for this hearing. And given her reaction to his comment, I think she knows exactly.
Good afternoon. Can you hear me?
I can.
And I've got your first name. I don't want to mispronounce your last name. How do you say it?
Grice.
Grice. All right. Miss Grice, I'm not sure this is appropriate attire for a court proceeding, but I'm just going to get through this and proceed. This is file number 24320SC, Lacey J. Grice versus Justin Matheny. Would you please raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes, Your Honor.
All right. This is a claim for $3,650 for money that you allegedly lent to Mr. Matheny to repair his vehicle. He paid a small amount back and never paid any more. Is that correct?
Yes, Your Honor.
What was your relationship with him at that time?
He was honestly just a friend, you know what I mean? He would like call me and like talk about his problems and stuff, and I was like kind of there for him. He had a job working at Doc's Foundry. I just didn't think that there was any way he wasn't gonna pay me back, honestly. There was
Well,
no
Metal
reason for it.
Technologies pays a good wage, but he's not here. So
I bet he made every excuse in the book to avoid being served. But he is aware of the court day. I mean, he spoke to Bruce on the phone and pretty much blew him off like he blows me off. Like, oh, I can't, my kid. Which I understand people have life circumstances or whatever, but if you take money from somebody and you say that you'll pay them back, you need to pay them back. Like,
yes, and they do. So I find by default that he owes you $3,650 plus court costs of $83.50 and $89.02 for a total of $3,822.52. Now, getting the money is the easy part. Or excuse me, getting the judgment is the easy part. Getting the money is the hard part. He has 21 days to pay this, or he's subject to garnishment of his wages or other collection remedies. If he does not pay, I suggest that you come here to the courthouse in Centerville and ask for a discovery subpoena. We're going to do a little one of those in a little bit if Miss Taylor can get her phone unfrozen.
okay.
Anyway, I believe he's still on Elm Street.
Mm-hmm.
So you have a money judgment. You can use it to seize his wages, garnish bank accounts, that sort of thing. But he has 21 days to pay. I don't expect that he will. He didn't respect the hearing enough to come. Do you have any questions?
I do not, sir. So after the 21 days, I would come in and ask for a
Discovery subpoena.
discovery subpoena. Okay.
All right, thank you. You're good
All
to
right.
go.
Thank you. Okay. Have a great day.
Thank you. Thought maybe the better we got that off, the sooner that we got that off the screen, the better. Judge Pattison would have allowed her to come into court.